Lawmakers in the Senate and House of Representatives have resolved to appeal the judgment which directed the Attorney General of the Federation, AGF, to delete Section 8412 of the newly signed Electoral Act, coming under Order 42 of the Senate Standing Orders on Personal Explanation. Thompson Sakibo, Senator representing PDP Rivers East during plenary, challenged the judgment of the court. Sakibo explained that the National Assembly is empowered by virtue of its provisions to make laws for the peace, order and good governance of Nigeria. For members in the lower chamber, the clause in question is directed at political appointees and not civil servants. They insisted that the court passed a judgment on a matter which was not included in the Electoral Act passed by the National Assembly.
The Senate believes that the Senate of the Federal Republic of Nigeria should show concern on the judgment, especially when she was not given opportunity to represent herself in a matter such as this that emanates from her legitimate functions. The Senate finally believes further that letting the judgment to go without concern will become a precedent on which any person could go to the court and obtain judgment to ridicule the good intentions of the National Assembly as an institution. For the court to set aside the judgment, as the judgment was reached without due consideration of the conventional interpretation in Section 318 of the 1999 Constitution as amended.
The content of the motion is straightforward, is clear enough, and the resolution sought is also clear enough. And therefore, on the basis of this, Mr. President, distinguished colleagues, I want to urge that without much ado, I invite and request humbly that my colleagues do consider this motion as submitted and to say that we ask that the question be put for us to consider the prayers.